the defendant is husband is ready to alienate the property to the, some other persons. He is having some bad some.
No, but what is the finding? Let us show us the finding.
Please, madam. Para
B and C property.
Para number 27, my lord.
27,
my lord. Running page number 31. Page 31.
Odi.
It is well settled the principal law that the court can presume the existence of joint family property, but there is no presumption that the nature of the property standing in the name of the one of the joint family has presumed as a joint family property. Hence, the burden on the person who assert the property, joint family property, and prove the aspect of the producer company evidence before the trial court. For the court, after joint
but the court has come to a finding. First two lines of that paragraph page, that there is no evidence to show B and C are purchased from joint family funds.
Yes, ma'am.
And then the court says there is no income from A schedule property to buy B and C.
My lord, schedule A property, my agricultural land, my lord. Out of which earning, my lord, the schedule B property purchase, my lord.
The respondents are restrained from alienating schedule B and C properties till the next date. Respondent is restrained from alienating schedule B and C property till the next date. Issue notice TCR to be summoned.
Number 53, Preeti Patil.
By insurance company, my lords, challenging the apportionment of the compensation granted, my lord. 70-30, there are two vehicles involved, 70% upon the appellant and 30% upon the other vehicle insurance company, my lord. I'm seeking interim order of stay, my lords. Here 35 lakhs 59,990 is the apportioned amount, my lords. 50% would be deposited out of it, my lords.
So 70% with the appellant, your company.
Yes, ma'am. Yes, ma'am. Total award amount is 50 lakhs 85,700 out of
all
which,
the three.
My lords.
All the three.
Total award amount, my lords. Total award amount is 50 lakhs 85,700, out of which 70% would be 35 lakhs 59,990. Out of this 35 lakhs, 50% would be deposited, my lords.
Yes.
And I am seeking dispensation in respect of respond number 4, my lords. And for R1 to R3 and R5 issuance of notice. R6 is HDFC.
Just a minute. You're filing memo?
For respond number 4.
Counsel for the appellant files a memo for dispensation of notice to respond number 4. Placing memo on reliance, notice to R4 is dispensed at the risk of appellant. Issue notice to respond number
R1 to R3 and R5, my lords.
R1, 2 and 5.
R1, R2 and R3 and R5.
R1, 2, 3 ಮತ್ತು R5.
ಆಮೇಲೆ R6, my lords, HDFC company, Manjunath Mallaya Shetty, my lords.
Manjunath Mallaya Shetty is directed to ask of notice to R6. R6. Pending disposal of this appeal, the operation and execution of the impugned award passed by the award passed by the tribunal in emission number 1150 of 2011-21 dated 23/11/2024 MECT Kalaburagi is stayed as far as the
appellant's liability to the extent
appellant's liability is concerned to the extent of
70%.
70%.
Please.
Subject to the condition that appellate subject to appellate depositing
50% of its share, ma'am.
50% of their share.
Yes. Yes.
50% of their share before the tribunal. Before the tribunal,
Yes, ma'am.
before the tribunal within 4 weeks.
From date of receipt, my lords, otherwise 6 weeks.
Date of receipt of copy, certified copy of this order. Upon such deposit,
50% may be released, my lords.
upon such deposit, the respond number yarella
My lords, R1 to R3, my lords, they are
Respond number
petitioners.
R1 to R3 are permitted to withdraw 50% of the deposited amount.
Please.
Deposit amount. Registry is directed to secure the TCA.
54 also
54.
same, my lords, but the dispensation would be for respond number 3, my lords.
R3 ಗೆ ಹಾಕೊಳ್ಳಿ.
And
Notice,
my lords,
1
1, 2 and
and
4.
4.
Yes, my lord.
R5 ಮಂಜುನಾಥ್ ಮಲ್ಲಯ್ಯ ಶೆಟ್ಟಿಯ.
Yes, my lords.
R5 ಮಂಜುನಾಥ್ ಮಲ್ಲಯ್ಯ ಶೆಟ್ಟಿ. Same order ಅಲ್ವಾ? Same ಅಲ್ವಾ?
Same, my lords, the dispensation would be for R3.
Yes, yes. Rest of the
Rest all
award
same,
same
yes,
ಅಲ್ವಾ?
yes.
Award same. What about 55?
55 also same, my lords, dispensation would be for R3. And R1 and R1, R2, R4 issuance of notice, R5 Manjunath Malaya Shetty.
ಮಂಜುನಾಥ್ ಮಲ್ಲಯ್ಯ ಶೆಟ್ಟಿ. ಮಂಜುನಾಥ್ ಮಲ್ಲಯ್ಯ ಶೆಟ್ಟಿ is R?
R5, my
R5,
lords.
same. Same. Rest of the order same. Huh?
Obliged.
Yes.
Mahesh Patil.
Requires hearing means after. Please. Relist date.
Number 57. DP Ambedkar.
Relist.
Still, no?
ಬರ್ತೀನಿ.
ಒಂದು MSR ಆಗಿದ್ದಾರೆ. ತಿರುಪತಿ. ಬರ್ತೀರಾ? Yes, sir. ಹತ್ತು ಇನ್ನೊಂದು ಓಕೆ ಅದು MSR ಎರಡೇ. ಅದು ಆಮೇಲೆ ಲಿಸ್ಟ್ 2 ಸೀಲ್ ನಂಬರ್ 1 ತೋರಿಸ್ರಿ. ನಮ್ದು ಸಿಂಗಲ್ ಕೈಲಿ ಮಾಡಿ ಫೋನ್ ಮಾಡ್ತೀರಿ. ಸರ್ ಅವ್ರು ಅಪ್ಲೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇದಾರ್ರಿ? ಹೌದಾ? ಸ್ವಲ್ಪ ಕಾಲ್ ಮಾಡ್ಬಿಡಿ ಸರ್, ಈಗ ತಗೊಂತಾರಂತ. ಸಿಂಗಲ್
in respect of section 194 of the Income Tax Act. Your Lordship, if I may read, para 13. This court is thus inclined to hold that the tax is payable on the interest on the amount of compensation under the MV Act, which with a rider that the interest should not be more than 50,000. That is a 50,000. Even the act which says, Your Lordship, if the interest is more than 50,000, then the TDS has to be deducted on that. Now, how this interest is to be calculated, Your Lordship? That it is per claimant per financial year, Your Lordship. That means to say, Your Lordship, in the present matter, the principal amount is 6,88,000, Your Lordship. The interest for 1 year it would be 6%. That is coming around, Your Lordship, 41,280. Your Lordship, this 41,280 has to be divided between the claimants, each claimants equally. In the sense, Your Lordship, now here there are 6 claimants. Now, if it is divided between the 6 claimants, it will come around 6,880 for each claimant, Your Lordship. That is again below 50,000, Your Lordship. Because, Your Lordship, the income tax runs on two things, Your Lordship. That is financial year and assessment year. Your Lordship, financial year, for example, the accident has taken place in the 2005. For the financial year of 2005 to 6, the interest of each claimant would be 6,880. That is less than 50,000, Your Lordship. So that being the case, Your Lordship, the TDS would not have been deducted. Is what I would like to submit, Your Lordship.
So we leave it at that. We'll just
Please,
notice the Supreme Court order.
Please, Your Lordship.
Which is that says Supreme Court order.
Uh,
A reference ಮೊನ್ನೆ ಇದೆಯಲ್ಲ ಯಾವ್ದೊಂದು codified Supreme Court
they have produced here, Lordship. Please.
issued notice and asked the central government to respond.
Please, Lordship.
Union of India is required to be implemented.
Correct.
WP is number, civil number 534 of 2020 in the apex court.
ಹೌದು. WP number
Civil
ಹಾ
534
ಹಾ.
oblique 2020.
So we'll await the
Bajaj
Please.
Alliance versus Union of India.
huh?
Bajaj Alliance versus Union of India.
Bajaj
Alliance, General Insurance Company versus Union of India.
Union of India.
Yeah. There are batch of cases are there.
All,
So let us await instead of adding to any confusion.
please, Lordship. In the accident has taken place prior to 2015, Your Lordship. That is when the section has been amended. In the case, Your Lordship, in the Orissa High Court judgment also, the accident has taken place prior to 2015. That is in the year 2013. And Your Lordship, the honorable, there is a division bench judgment, Your Lordship, which they have held that even if it is pre-amendment or post-amendment, TDS was not required to be deducted.
Let us see.
Please, Lordship.
After hearing, see Sanket,
Please, Lordship.
Appaji, amicus as well as learned counsel so and so for the appellant. It is noticed that the proceedings before the apex court in WP 534 of 2020, WP civil 534 of 2020, in the case of Bajaj Alliance General Insurance Company versus Union of India, may have a bearing on the issue that has arisen in the present case. Matter is adjourned, awaiting orders from the apex court. Full stop. Such order is passed to avoid passing conflicting orders. Full stop. Let us see.
Your Lordship, in fact, most of the other high courts, Your Lordship, they are following the practice that the TDS should not be deducted. Should not be deducted. Only this our state, it is not. No
Madras
judgments
High
have been
Madras
passed
High
by
Court
this.
has stayed proceedings regarding to the extent of TDS in all courts till it is decided.
Most
by
of the high
larger
courts
bench.
are following that practice, is what I would like to submit.
Let
Please,
us, let us
grateful.
Number 1.
ಅದೊಂದು ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಬೇಕಲ್ವ ನಂಬರ್ ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ ಚೆಕ್ The submission that was made by the petitioner is that insofar as some of the parties, the judgment debtors and the decree holders have settled. So in so far as such settlement is concerned, they have relied on some judgment which says that multiple FDPs can be drawn. So in so far as those which inter se they have settled, FDP may be drawn, remaining it can go on from whatever is. Insofar as it's settled.
Milord, of course, we discussed, Milord, about that, and I also called my counterpart also. But what they say, it is having its own ramifications about the shares, which property, where comes.
No, but they're saying it has been settled inter se.
No, Milord, it is not that simpliciter. Milord, of course, I also tried to prevail upon them because I'm sorry, Milord, I was absent for the
No,
last
that's-
two
that's-
occasions, but for some marriage,
No, that's
I'm
it.
extremely sorry. And
Hmm.
so over phone, I called. Then somehow they are not and asked me to argue the matter.
So what is the position now?
My Millard, what they said, Millard, I also told my friend also, almost what I am going to argue, I have made myself clear also. Millard, what is our contention, our client's contention is, the scope of the petition at present is whether the order passed by the court below to cross-examine the commissioner is correct or not. That is to be tested. What this type of order which is sought to be argued and wants to taken, Milord, is coming a little bit outside the scope of the
No,
petition.
but what is the order on IA 49?
Milord, what has happened, a commissioner was appointed
Yeah.
to make the division of the properties, Milord.
Hmm.
They have submitted the report, Milord. We have filed an objection. We have filed an application to cross-examine the commissioner. That is allowed. Against that order, they have come up in this writ petition. Order of the court below permitting us to cross-examine the commissioner is challenged in this petition, Milord. My submission is simplicity, the horse of the technicalities, inferences of laws. I am not on the technical ground. Even by abundant common sense and practicability, what the court has ordered, allowing me to cross-examine the commissioner, which could have been done by this time. One thing. Second thing, what all they wish to contend on the technicalities.
Can we still be kept open for consideration parallel to this?
Yes. Yes. And moreover, ಇಷ್ಟ್ರಾಗ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಆಗಿ ಎಲ್ಲ ಮ್ಯಾಟ್ರೆ ಮುಗಿದು ಹೋಗ್ತದಲ್ಲ ಅಂತ ನಾನು ಅನ್ನೋದು. ನೀವು
Just let's go to that order.
Please, my lord. That order is on, my lord, I'll read that portion also. That is, my lord, annexure, in page, annexure A 40, page 40.
Yes, read the order, let us.
Please. In the application, the applicant defendant number 33 has filed so and so IA seeking permission to examine the commissioners. In the accompanying affidavit, it is stated that the applicant is the defendant number 33 in this FDP. The defendant so and so have filed the objection to the commissioner report. The commissioner has not carried out the commissioner work as per the preliminary decree passed in special OS number so and so. The plaintiff and the defendants are already partitioned the land survey number 105. The plaintiff and defendant have sold their share. Therefore, the question of again partition of the said land does not arise. The commissioner has carried out the commissioner work without following the due procedure. The commissioner has filed false report before this court. The commissioner has carried out the commissioner work as per the memo of instructions filed by the plaintiff, which is not in accordance with law. The court has not made any order regarding the fixation of the valuation of the buildings and house properties, but the commissioner has carried out the commissioner work regarding fixation of the valuation of the buildings and house property. Therefore, Many questions are involved in the commissioner work. Therefore, examination of the commissioner is very much necessary for the final disposal of the present proceedings. Therefore, pray to allow IA number 49. Per contra, the plaintiff filed objection to IA so and so. In the objections, it is contended that the defendant so and so are claiming of having purchased one of the suit property bearing survey number 105 of Mudnal village, which was during the pendency of the suit at various levels from defendant number 1 to the extent of share of the deceased defendant number 1 in the present proceedings, which is illegal, and there is no decree in favor of the aforesaid defendants. Therefore, the question of summoning the court commissioner does not arise. The averments made in para 1 of the affidavit alleging that the court commissioner has filed court commission report, for which the division effected by the court commissioner is not in accordance with preliminary decree so and so is uncalled for. The further averments that the aforesaid defendants are in possession of the possession as per the sale deed is also uncalled for, as the said same is illegal, as the Honorable Court has already granted relief of mean profits during all the years pendency of the suit till handover of the possession as per the preliminary decree to the extent of the enhanced share in view of the death of certain shareholders as per the preliminary decree in favor of the plaintiff, and also compromised by certain plaintiffs and defendants in favor of plaintiff number 1. Therefore, the averments made in para 1 of the affidavit are baseless. Further, the alleged purchasers like the defendants and others have only delaying or protracting tactics by filing one or the other application or objections at the certain stages of the proceedings to obstruct the further proceedings. Under such circumstances, the prayer made in the affidavit is uncalled and the application is not maintainable. It is further contended that the defendants have filed objections to the main petition and have admitted that they would be happy if the share allotted to the deceased defendant number 1 is allotted to them, which is 16.66% only. Further, the said defendants have entered in the witness box as DW witnesses and have admitted they are willing and ready to take the share allotted to the deceased defendant number 1. The deceased defendant number 1 has also, as DW1 witness, has admitted having sold his share to the defendants. Under such circumstances, the defendants have no vice to unnecessarily obstruct the passing of the final decree by filing an application which is not maintainable in law, as the said defendants have not preliminary decree in their favor. Further, the plaintiff number 1 has already produced rulings as well as section 351 of Mullah Hindu law, which says that the alleged purchaser, if has any claim after the final decree to the deceased defendant number 1, in such property, the alleged purchasers have to seek partition by filing a separate suit, and they cannot claim any share or any sort of relief, or nor can create any obstructions by filing such application to summon court commissioner without having any right over the suit property. Therefore, the present application is devoid of merits and liable to be dismissed with cost. Hence, the present application filed by the defendants may be disposed of along with the passing of the final decree. I have heard so and so. Point for consideration: whether the applicant defendant number 33 has made out sufficient grounds to allow IA number 49. Reasons: the plaintiff has filed so and so. May I skip that portion? It will be repeated. Then para 8. At this stage, it is just and modula or contention. Repeat again. At this stage, it is just and proper to reproduce Order 26, Rule 10 of CPC, which reads as under. Rule 10, Order 26 of CPC. The Commissioner, after such local inspection as he deems necessary, and after reducing to writing the evidence taken by him, shall return such evidence together with his report in writing signed by him to the court. Rule 2, Sub-Rule 2. Report and depositions to be evidence in the suit. The report of the Commissioner and the evidence taken by him shall be evidence in the suit and shall form part of the record. But the court, or, kindly mark this, with the permission of the court, any of the parties to the suit may examine the Commissioner personally in open court touching any of the matters referred to him or mentioned his report or as to his report or as to the manner in which he has made the investigation. Rule 3, commissioner may be examined in person. Where the court is for any reason dissatisfied with the proceedings of the commissioner, it may direct such further inquiry to be made as it shall think fit. The following aspects can be noticed in Order 26, Rule 10, that the meaningful reading of the aforesaid provisions, it is clear that commissioner report can be secured to elucidate the matter in dispute, and the report of the commissioner and the evidence taken by the commissioner shall be evidence. The court may, in its discretion, examine the commissioner or any matter concerning the report. There is no compulsion to examine the commissioner. However, if the objection is filed to the report and the party filing objection seeks to examine the commissioner, then the commissioner should be examined. In the present case, the defendants have filed the objections to the commissioner report, and they have filed this present application for the purpose of examination of the commissioners. Therefore, I am of the opinion that it is just and proper to examine the commissioners in the present case. If the application is allowed, no harm will be caused to the plaintiff. On the other hand, if the application is not allowed, the defendants would cause irreparable loss, which cannot be compensated in terms of money. Therefore, it is just and proper to allow.
Now, irrespective of the order on 49, we could keep open your contention, saying that it's at liberty for you to move the court seeking for passing of FDP in so far as some of the
Compromise.
judgment declarers and decree holder with whom you have settled it. Let the court examine.
Yes.
ನಾನು ಅನ್ನೋದು ಒಂದು ಮೈ ರಿಕ್ವೆಸ್ಟ್ ಮೇಲೆ ಅದ್ರ ಬಗ್ಗೆ ಅದು ಸ್ಕೋಪ್ನು ಇಲ್ಲ. ಬೈ ನೋ ಸ್ಟ್ರೆಚ್ ಆಫ್ ಇಮ್ಯಾಜಿನೇಷನ್ ವಾಟ್ ಹಿ ಇಸ್ ಆರ್ಗ್ಯೂವಿಂಗ್ ಕ್ಯಾನ್ ಬಿ ಗ್ಯಾದರ್ಡ್ ಔಟ್ ಆಫ್ ದ ರೆಕಾರ್ಡ್ಸ್. ಈಗ ಅದನ್ನ ಅಬ್ಸರ್ವ್ ಮಾಡಿ ಅದಕ್ಕೆಲ್ಲ ಯಾಕೆ ಅದು ಇದು ಮಾಡೋದಂತ
ಅಲ್ಲ, ಹಳೆ ಮ್ಯಾಟರ್
ಅಲ್ಲ, ಹಳೆ ಮ್ಯಾಟರ್ ಐತೆ. ಲೆಟ್ ದೆಮ್ ಮೂವ್. ಇಫ್ ದೇ ಡೋಂಟ್ ಅಲೋ, ಇಟ್ಸ್ ಓನ್ಲಿ ಹಿಸ್ ಓವರ್, ಇಟ್ ಈಸ್ ಹಿಸ್ ಓರಲ್ ಸೇ. ದೇರ್ ಇಸ್ ನಥಿಂಗ್ ಆನ್ ರೆಕಾರ್ಡ್ ಟು ಶೋ that he has made such a request, court has refused or deferred, even he has made such a request in writing. In the absence of that, merely ಅವರು ಹೇಳೋದ್ರ ಮೇಲೆ ಅದು ಮಾಡೋದು ಬೇಡ. ಇದು ಸ್ಕೋಪ್ ಇಷ್ಟೇ, ಅದು ದಯವಿಟ್ಟು ತಾವು ಇದ್ರ ಮೇಲೆ ಮಾಡಿದ್ರೆ ಬೆಟರ್. ಲೆಟ್ ಹಿಮ್ ಮೂವ್ ಇಟ್. ದಟ್ ಲಿಬರ್ಟಿ ವಿಲ್ ಬಿ ಆಲ್ವೇಸ್ ದೇರ್ ಫಾರ್ ಹಿಮ್.
Yes, Dharwadkar, they say that you have not brought this to the notice of the executing court at all.
No, sir, I have brought it. Even written arguments have been filed on the main matter, sir.
So that you point out anywhere that this aspect, that insofar as some of the parties matter is settled,
Yes, sir.
you have raised it before the executing court.
Yes, sir. And it is on the record of the trial court that there has been settlement in regard to so many properties by mediation. It was referred to the mediation.
No, but have you raised that?
Yes, sir, I have raised in my petitions.
Elli torsi.
Please.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಸಾವಿರ ಇನ್ನೊಂದು ಏನ್ ಬರುತ್ತಂದ್ರ, ಏನ್ ರೇಜ್ ಆಗ್ಯದು, ಯಾರ ಅಗೇನ್ಸ್ಟ್ ರೇಜ್ ಆಗ್ಯದು, ಯಾವ ಪ್ರಾಪರ್ಟೀಸ್ ಅದಾವು, ಅವು ಏನೂ ಗೊತ್ತೇ ಇಲ್ಲ ನಮ್ಗ. ಈಗ ವಿ ಆರ್ ಇನ್ ಡಾರ್ಕ್ ಮೆಲಾಟ್. ಅದಕ್ಕ ನಾನು ಅನ್ನೋದೇನು, ನಥಿಂಗ್ ಪ್ರಿವೆಂಟ್ಸ್ ಹಿಮ್ ಮೂವಿಂಗ್ ದ ಕೋರ್ಟ್ ಬಿಲೋ. ಮೂವ್ ಮಾಡ್ಲಿ, ಅವ್ರು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರು, ಅಥವಾ ಇಫ್ ದ ಕೋರ್ಟ್ ಈಸ್ ನಾಟ್ ಅಟ್ ಆಲ್ ಪಾಸಿಂಗ್ ಅಂಡ್ ಸ್ಲೀಪಿಂಗ್ ಓವರ್ ದ ಮ್ಯಾಟರ್ ಅಂದ್ರೆ ಇಲ್ಲಿ ಬಂದು ಅವಾಗನ ಕೇಳಲಿ ಅಂತ ನಾನು ಅನ್ನೋದು. ಯಾಕಂದ್ರೆ ಒಂದೋಗಿ ಒಂದಾಗದ್ ಬೇಡ ಅಂತ ತಿಳಿದಂತ ಹೇಳಿ.
Let us see.
ಹಾ, ಪ್ಲೀಸ್.
Para 18 of my writ petition, sir. at page 29.
Yes, read.
May I please, sir, last 5 lines. Under such circumstances, the court below failed to appreciate that to draw final decree, there is no objection from defendants 1 to 9, who are preliminary decree holders, and certain defendants 1 to 9 have already settled the matter with the plaintiff petitioner by accepting the court commissioner report. Out of the 15 properties as per schedule ABCD, all the defendants 1 to 9 decree holders have settled the matter by filing compromise petition before the mediation center, and the alleged rights being claimed by the present respondent defendants who are purchasers during the final decree proceedings cannot be decided in this matter. Under such circumstances, the acts and activities of the court below are not in the interest of justice to protect the decree holder, but are contrary to the law. Therefore, the impugned order passed by the court below needs to be squashed. I have made a list of the properties, sir, that have been settled before the.
No, but whether the present respondent,
He has not settled, sir. Regarding that property, we are not seeking any final decree to be drawn.
okay, I'll keep this open for you.
Yes.
And for the court while disposing it of.
Please
The
let those matters that have been settled regarding that, if the final decree is to be drawn, sir, at least to that litigation will be mitigated. Because these people are going to take me up to Supreme Court, sir. It is not going to end here only.
ದಯವಿಟ್ಟು ತಾವು ಅಂದ್ರೆ ನಾನು ವಿತ್ ಓಪನ್ ಮೈಂಡ್ ಐ ಆಮ್ ನಾಟ್ ಬೀಯಿಂಗ್ ಐಡೆಂಟಿಫೈ ವಿತ್ ದ ಮ್ಯಾಟರ್ ಆರ್ ದ ಪಾರ್ಟೀಸ್. ನಿಮಗೆ FDP ಬೇಕಾಗಿದೆ, ಯಾಕೆ ನೀವು ಪೀಸ್ ಮಿಲ್ ತಗೊಂತೀರಿ? ವಿ ಡೋಂಟ್ ಹ್ಯಾವ್ ವಾಟ್ ವುಡ್ ಬಿ ದ ರಿಪರ್ಕಷನ್ ಆಫ್ ದ ಸೋ ಕಾಲ್ಡ್ ನೀವೇನ್ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ ಮತ್ತೊಂದು ಮಗದೊಂದು ಅಂತ ತಿಳಿದನ್ನೋದು ಇದ್ರ ಸ್ಕೋಪ್ನು ಇಲ್ಲ. ಒನ್ಸ್ ಫಾರ್ ಆಲ್ ಮಾಡ್ಕೊಳ್ರಿ, ಅಲ್ಲಿ ಮೂವ್ ಮಾಡ್ರಿ. ಅಲ್ಲಿ ಅವ್ರು ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತಾರ, ಯಾರು ಏನಾಗ್ತಾರ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಈಗ ಏನಾಗ್ಬಿಡುತ್ತೆ, ಹೈಕೋರ್ಟ್ನವ್ರು ಇದು ಹೇಳ್ಯಾರ ನೋಡ್ರಿ ಸಾಹೇಬ್ರ ಅಂತ ಹೇಳಿ ಅಲ್ಲಿ ಹೋಗಿ ಹೇಳಿ ಮಾಡಿ ಮತ್ತೆ ಅದು ಒಂದಾಗದ್ ಬೇಡ. ನೀವು ಇದೇ ದೃಷ್ಟಿದಾಗ ಮೂವ್ ಮಾಡ್ರಿ. ಈ ಸ್ಕೋಪ್ ಆಫ್ ದ ಪಿಟಿಷನ್ ವೆದರ್ ದ ಆರ್ಡರ್ ಆಫ್ ದ ಕಮಿಷನರ್ ಟು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಈಸ್ ರೈಟ್ ಆರ್ ಅದಿದಂತ. That what he has read, my lord, he has read as a supportive ground for quashing the order of the trial court. Thus the order is illegal anta. It is not that the trial court has passed this order based on those things. If that were to be so, then my lord, one can traverse and meet that point. It is his assumption. Nowhere the court below in its order has touched upon those things. I heard that for these reasons I am allowing the cross examination. Had it that were to be there, then his contention would have been proper, my lord. It is his contention. On that ground the impugned order needs to be quashed.
Sir, these are the lease pendants purchasers.
That is a
Let that aspect may be clarified, sir, as to what are the status of these people and the rights. Otherwise, there will be no end to my litigation. My father has died. Now these people would be troubling me up to the Supreme Court. Only for one property, I should not lose my 10 properties which are undisputed.
Allah, ನಿಮಗೆ trouble
I should not be troubled by family members because it is not ending in the court as far as those properties that have been settled.
ಅಲ್ಲಲ್ಲ, ನಿಮಗೆ
Who is he to object?
ಆಯ್ತು, ಕೊಟ್ಟಿವಂತೆ ತಿಳ್ಕೊಳ್ರಿ. ಇನ್ನ ಒಂದು ಟ್ರಬಲ್ ಇರೋದು ಏನದ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತೀನಿ ಕಮಿಷನರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋದ್ರಲ್ಲಿಂದ ಏನ್ ಟ್ರಬಲ್ ಆಗ್ತದ ಈಸ್ ದ ಕ್ವಶನ್ ಇನ್ ದಿಸ್ ರಿಟ್ ಪಿಟಿಷನ್.
They are not the decree holders. They have not filed
the very fact that they are objecting to my cross examination of the commissioner speaks volumes in between the lines. It could be anybody's guess. Otherwise they would not have objected for this.
let us the petitioners. Is the decree holder has filed the present petition assailing the order passed on IA number
49.
Under section 151 of CPC, filed by defendant number 33 seeking permission to examine the commissioner. Full stop. Said application has been disposed of by the executing court in FDP number 2 of 2013. Full stop. The application filed by defendant number 33 is in order to examine the commissioner who has submitted his report. Full stop. It is no doubt the contention of the plaintiff that the respondent or lispendent's purchasers
Yes.
and hence are not entitled to cross-examine the commissioner. Full stop. Various other contentions have been raised. Full stop. Objections were filed to IA number 49 to the effect that there are no merits in the claim of the said defendant, that the alleged purchaser, that is defendant number 33, is required to file a separate suit and seek for partition and cannot claim any share nor can create any obstruction by filing application to summon the court commissioner. Full stop. Peruse the order on IA number 49. Full stop. The executing court has noticed the contentions of both parties and has observed the scope of Order 26 Rule 10 relating to the procedure to be followed by the commissioner. Full stop. Court has noticed provision of Order 26 Rule 10 Sub Rule 1 and 2 whereby the commissioner's report and evidence taken by the commissioner, it is observed, shall be evidence, and that the court may examine in its discretion the commissioner or any matter concerning the report. Full stop. The court has observed that if objections are filed to the commissioner's report and party filing objection seeks to examine the commissioner, then the commissioner could be examined. Full stop. Next. Court has noticed that the defendants have filed objection to the commissioner report and having filed such objections have sought for examination of the commissioner and accordingly allowed the application. Next. Heard both sides, learned counsel appearing for the petitioner has raised various contentions, including that the parties are required to, including that the defendant number 33 is required to file a separate suit. Full stop. Next. It is further submitted that cross-examination, if permitted, of the commissioner would result in prolonging the proceedings when, as regards some items, the dispute between the judgment debtor and decree holder have been settled. Full stop. Attention is drawn to amendments in para 18. Learned Counsel Shri Basurajkar Reddy, appearing for the defendant number 33, would point out that the only question is before the court is as regards correctness of the order passed under IA number 49 and the contention raised by the petitioners are matters touching the merits of the matter and cannot be adjudicated at this stage. Next. It is to be noticed that application is filed by defendant number 33 for examination of the commissioner. Full stop. A bare reading of Order 26 Rule 10 would indicate that any of the parties to the suit may examine the commissioner touching upon any matters referred to him or mentioned in his report, or as to the report or manner in which investigation has been made. Full stop. Further, under Order 26 Rule 10, Sub Rule 3, the court, if dissatisfied with the proceedings of the commissioner, may direct further inquiry to be made. Next. Insofar as the order passed by the executing court, this court finds no jurisdictional error calling for interference at this stage. If the court were finally to be of the view that the contention of the petitioner regarding the defendant's necessity to file a separate suit is also a contention to be considered at an appropriate stage. At this stage of the matter, no cause is made out to enter into contentions raised on merits, and accordingly no ground is made out for interference with the application, with the order passed. Next. Insofar as a contention raised by counsel for the petitioner as found in para 18, it is to be noticed that the contention raised at para 18 of the petition is as follows. Next. Only under such circumstances in the Konevaru. Under such circumstances. Next. Must be noticed that the said aspect may not have a direct, the said contention may not have a direct nexus with the right to cross-examine the commissioner by defendant number 33. Next. However, it is a case made out by the petitioner that the suit is of the year 1969, and insofar as undisputed settlement between decree holder and some of the judgment debtors, the petitioner may be at liberty to press for appropriate relief as against such undisputed settlement. Next. While the court would not enter into such contention on its merits, we keep it open for the petitioner to raise the contention as found in para 18 in an appropriate manner, which the court may consider appropriately. Accordingly, according the petition is disposed of. It's made clear that as the FDP relates to the year 2013, the court to endeavor to dispose of the execution proceedings at the earliest. And if the FDP is the oldest case pending before the court, needless to state, the court to take up the matter on priority and dispose it off at the earliest. All contentions are kept open. Accordingly, petition is disposed of.
Would they be permitted to cross-examine the court commissioners?
Let them process.
They are not decree holders.
Huh?
They are not decree holders.
Correct. Under
This
order
pendant says,
under order 26 rule 10 sub rule 2 it says any party. Now even if they cross-examine your contention, let it be examined if they are good to file a separate suit.
sir, in the order that has been passed for cross-examination of the court commissioner by the court, it has not considered the lease pendants and the decree being passed in favor of these opposers.
Looks
So
correct.
let that order be set aside and the opportunity be given to the trial court to give findings on that, sir.
No, that contention will keep it open. All your contentions
Sir, if-
are on merits. Now we are only at the stage.
No, sir. My submission would be, sir, order passed under IA 49 suffers from giving findings on whether these people who want to cross-examine me, do they have any decree in their favor?
That same question may be decided while deciding the merits of the claims in the FDP. Now, let's assume you are saying that they are list pendants purchasers, so they have no right better than that of their vendor.
Vendor.
And vendor has either suffered or does not have. That aspect can still be considered. Now we are only at the stage, no doubt there may be some delay, but that's a matter to be taken care of. We will observe that they are not going to take unnecessary adjournments and complete that process within 1 or 2 dates. Finally, your contentions on merits I'll say are specifically kept open. I'll keep it open for them to consider.
That would,
but
that
not
would
at this-
ultimately, Lordship, that would ultimately would not decide on the point of the lease pendants because.
Correct. That
No,
question is to be
may-
determined at a later
May I
stage,
make a
not-
submission, sir? On the merits of the main petition, there has been evidence by both the parties. And in the evidence, they admitted that if anything is to be given to defendant number 1, they are ready to take it. And when the court commissioner was appointed, they didn't file memo of any instructions to the court commissioner. They kept silent. Now say that what I am doing is wrong. Now what will happen is, sir, now the court commissioner report is submitted because they didn't file any memo of instructions. They didn't make any claim to that. Or they even didn't object to the memo of the instructions that were filed by the plaintiff. Now, if they are to be allowed to cross-examine, they will unnecessarily ask all these unwanted things to the court commissioner who doesn't know the court commissioner's job is what, as per the decree, he wants to divide the property, that's all. They have not made any claims that a particular portion in this part should be given to me, or my claim is 5 acres, you have given only 2 acres. That is not their contention. So in light of that, what will happen is, sir, again, there will be unwanted bouncers in the matter for no reason. Had they filed memo of instructions, well, he has violated, yes, they could be permitted to cross-examine.
No, but you just look at it. Suppose the defendant is placed ex parte. Still, he can cross-examine the plaintiff, isn't it?
Sir, that's
Just,
the
now
rights
what-
of these people is subject to, they purchase the property at their pearls.
Allow one more.
Not that decree was passed already. After that, seal deed they have taken. And nowhere till today, the objections they have filed, they say what is the quantum of the property they have purchased.
Just hold on. You have purchased from first defendant.
First defendant.
I'll also make it clear that the scope of inquiry must be limited to, cannot be beyond entitlement of D1.
As on the date of the sale.
ಅಲ್ಲಲ್ಲ ಸಾಹೇಬ್ರೆ ಒಂದ್ ನಿಮಿಷ. ಈಗ for a minute, let us forget about contentions of both of us on this point. Even the rule, sub-rule 2.
Any party.
ಅಲ್ಲಲ್ಲ, any party ಅಲ್ಲ. Even the court has power to examine it.
No, correct.
ಹಂಗಿದ್ದೊತ್ನಾಗ ನಂದ್ ಕಂಟೆನ್ಷನ್ ಅದ ಕಂಟೆಂಟ್ ಕೋರ್ಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ, ನಂದು ಇದು ಮಾಡಿಲ್ಲ, ಅದು ಇದು ಅಂತ ತಿಳಿದಂತ ಅನ್ನೋದನ್ನ ಬಿಡ್ರಿ ನೀವು. ಅವ್ರ ಕೋರ್ಟ್ನವ್ರು ಮಾಡ್ಯಾರೋ ಇಲ್ಲೋ, ಬಟ್ ದ ವೆರಿ ಫ್ಯಾಕ್ಟ್ ಆಫ್ it appointing a commissioner can be made relatable to the power of the court to examine the commissioner. But by that dimension also this order can be justified.
One observation. Needless to state that the dismissal of the writ petition would not have the effect of an adjudication on the contentions raised by the petitioner on the substantive rights of defendant number 33 as raised in the petition and as contained in the objections filed to the application of defendant number 33 under order 26 rule 10. Please stop. Such objections are kept open to be considered at the time of hearing while drawing up of the final decree.
Please.
Full stop. The court also to ensure that there is no procrastination of the proceedings, that defendant 33 is not to be permitted to take unnecessary adjournments, and the unnecessary adjournments. That's all. Let us see.
Please.
Let the litigation come to an end at the earliest. 1969 suit.
ತಂದಿ ಮಕ್ಕಳು. ಬರ್ತೀನಿ ಸಾಹೇಬ್ರೆ.
Thank you.